सबका मेरे चैनल लीगली पॉलिटिकल पे बहुत बहुत स्वागत है। और आज जो हम लोग डिस्कस करने वाले हैं एक इम्पॉर्टेंट क्वेश्चन जो कि डाइवोर्स बाय म्यूचुअल कंसेंट से रिलेटेड है। सेक्शन 13B1 एंड सेक्शन 13B2 ऑफ हिंदू मैरिज एक्ट 1955। इस क्वेश्चन को सुप्रीम कोर्ट ने डिस्कस किया था इन लैंडमार्क जजमेंट ऑफ रजत गुप्ता वर्सेस रूपाली गुप्ता। डेट ऑफ डिसीजन है 15 मई 2018। तो इसमें एक क्वेश्चन अराइज होता है कि वेदर अ पार्टी विच हैज़ अंडर अ सेटलमेंट एग्रीमेंट decreed by a court undertaken to file a petition under section 13B1 or a motion under section 13B2 of the act 1955 or both, and has also undertaken to appear before the said court for obtaining decree, can be held liable for the contempt if the said party fails to file or appear in the petition or motion or both to obtain divorce in view of the option to reconsider or renege the decision of taking divorce by mutual consent under section 13B2 of the act. The question the answer to the question that the court has given is in affirmative, that is yes. The distinguishing feature of Section 13B of the Act 1955 is that it recognizes the unqualified and unfettered right of a party to unilaterally withdraw the consent or reconsider or renege from a decision to apply for divorce by mutual consent, notwithstanding anything or any undertaking given in any legal proceeding or recorded in any settlement or joint statement in or outside the court, resulting in a consent order or decree to cooperate with the other spouse to file a petition under section 13B1 or a second motion under section 13B2 of the act or both. Withdrawal of the consent even at the stage of the inquiry as contemplated under section 13B2 is also in exercise of the right available to the party under the very same provision. In other words, the mutuality of the consent to divorce should commence from the stage of filing the first motion under section 13B1, and it should continue at the time of moving the second motion under section 13B2 of the act till such time that the court completes the inquiry and a decree of divorce is finally passed. The said element of mutual consent is a sine qua non for passing a decree of divorce. This being the legal position, the defaulting party cannot be compelled to file or appear in the petition or motion or both to obtain the divorce by mutual consent. In other any other view will not only impinge on the jurisdiction of the court, which has an obligation under the statute to undertake an independent inquiry before passing a decree of divorce by mutual consent, it will also encroach upon a statutory right vested in a party under section 13B2 of the act and go against the very spirit of the provision, at the heart of which lies the right of the party to reflect or revisit and retract from its decision of going ahead for grant of divorce by mutual consent during the cooling off period. At the same time, the defaulting party can be held liable for civil contempt on the ground of breaching the terms and conditions incorporated in an undertaking given to the court or made a part of a consent order or decree. In the event the aggrieved party approaches the court for initiation of contempt proceeding against the defaulting party for willful or deliberate breach of any of the terms and conditions of an undertaking of settlement or agreement or consent order or a decree and takes a plea that as a consequence thereof he or she has been placed in a disadvantageous position or has suffered an irreversible or grave prejudice, the court, in exercise of its inherent powers of contempt, supplemented by the by the Act of 1971, has the requisite jurisdiction to entertain the petition and direct the restoration of the status quo ante in every possible way, besides directing the defaulting party to disgorge all the benefits, advantages, privileges that have would have inured in its favor and restoring the party to the position that was before they had arrived at uh, such a settlement or agreement or undertaking, and or before the consent order decree was passed in terms of settlement or of settlement arrived at undertaking recorded, the court has the discretion to punish the defaulting party for civil contempt, depending on the facts and circumstances of the given case. Thus, the contempt jurisdiction operates in a different field and is uninfluenced by the fetters imposed on a court under the Act of 1955. The only rider to the above is that no direction can be issued, even in contempt proceeding, to compel the defaulting party to give its consent for a decree of for a decree of divorce by mutual consent, as it is opposed to the policy, object, and intent of Section 13B of the Hindu Marriage Act. So this was the matter that was discussed in the judgment of Rajat Gupta versus Rupali Gupta. Many other questions were also discussed that we will discuss in another video. So if you want more questions that were discussed in this case, do comment, and if you like this video, do subscribe also. Thank you.